Everyone, thanks for joining. My name is Kelsey Atkinson, and I am a staff attorney with the Legal Aid Foundation of Los Angeles. And I'll be presenting today's webinar on COVID-19 rental debt in small claims court. So the presentation today breaks down into three parts. First, we're going to discuss what is COVID-19 rental debt. Then in the second part, we'll talk about what rights and protections apply to COVID-19 rental debt. And in the third part of the presentation, we'll talk about what to do if you've been sued for COVID-19 rental debt. Before I get into today's content, I also just want to point out that we will not be discussing the unlawful detainer or eviction process in this presentation. If you're looking for more information or resources relating to eviction, I encourage you to check out the Stay Housed LA website at stayhousedla.org. You can submit an intake for assistance on their website, or you can submit an intake by calling the number on the screen. The Stay Housed LA website also has a number of different workshops on a variety of topics, including topics on the eviction protection and eviction process on their website as well. So to get into the content for today, as I mentioned, the first thing we're going to discuss is what is COVID-19 rental debt. Throughout the COVID-19 pandemic, starting in 2020, state and local ordinances protected tenants who were financially impacted by COVID-19 from being evicted for non-payment of rent. State law created this term called COVID-19 rental debt, and it has a very specific definition. So it's defined under state law as any unpaid rent or financial obligation arising from the lease, such as utilities, for the months of March 1st, 2020 through September 30th, 2021. As many folks already probably well know, tenants in the city and county of Los Angeles had additional protections that allowed them to defer rent after this September 30th, 2021 date. And we'll discuss these protections in detail later in the presentation. But first, I'm going to continue to talk about your rights under the state law, and before we dive into additional protections that were in place. So the rent tenants could not pay during the pandemic. This COVID-19 rental debt is considered deferred. The rent is not canceled. The rent needs to be paid back. The state legislature gave landlords the ability to sue for recovery of COVID-19 rental debt in small claims court or in limited or unlimited civil court actions. In particular, the state legislature removed the small claims court limit for cases seeking COVID-19 rental debt. Normally, in a small claims case, the amount of money that can be asked for in the lawsuit is capped at $10,000, meaning that a person can be sued for no more than $10,000 in a standard small claims case. However, for COVID-19 rental debt suits, so recovery of unpaid rent from that March 1st, 2020 to September 30th, 2021, the cap is removed, meaning a person can be sued for any amount of money over $10,000 in a small claims court action for rent that came due during those months. These suits to recover COVID-19 rental debt in small claims court or in general civil court are different from an eviction. The only way a tenant can be formally evicted or required to move out for non-payment of rent is if the landlord follows the proper eviction or unlawful detainer process. A suit for COVID-19 rental debt on its own is not an eviction. However, these rental debt suits are still important to understand in terms of understanding what they are and how to respond appropriately. A rental debt recovery suit is essentially the landlord coming to the court and asking for what's called a money judgment. So a judgment or an order from the court saying that you owe the landlord a certain amount of money. Once that judgment is entered by the court, the landlord then has the ability to try to collect the judgment through means such as wage garnishment, bank levies, or property liens. And depending on the amount of rent owed or other debts that a person may have, the person might also consider filing for bankruptcy to release the debt. So these cases can still have a big impact on your financial well-being, even if it's not an eviction case. And these money judgments are valid for 10 years and can be renewed for an additional 10-year period after that. So these judgments remain valid for a very long time, meaning the landlord can try to collect the money owed on the judgment for this entire decade-long period plus. Now that we've talked a little bit about what is COVID-19 rental debt and and I want to talk about some of the rights and protections that apply to COVID-19 rental debt. First and foremost, these rights are afforded primarily under state law. So these are rights that apply to tenants across the entire state of California, not just Los Angeles tenants. I'll point out when we're going to be moving into talking about some of the local Los Angeles protections. The first line of defense that tenants had in terms of trying to pay back the rent deferred during the pandemic was the rental assistance program. And the state rental assistance program was called Housing is Key. Eligible households were able to receive up to 18 months of rent payments through the Housing is Key program. The rental assistance application closed as of March 30th, 2022, and no new applications can be submitted. There are still some lingering cases out there as of the recording of this video in November 2023. So if you're in that situation, you can check the status of your application on the Housing is Key website. Additionally, if your application was denied, you may be able to file an appeal, and information for appeals and how to go through that process is also on the Housing is Key program website. The other protection that is afforded to tenants with respect to rental assistance is that in order to sue for COVID-19 rental debt, landlords are required to attach to their legal complaint proof that they made a good faith effort to investigate, cooperate, or seek rental assistance on behalf of the tenant. So the landlords are required to attach this documentation to the complaint, the legal document they file when they start a lawsuit for recovery of COVID-19 rental debt. Additionally, the court should not enter a judgment for a COVID-19 rental debt if there is still a pending rental assistance application on file with the Housing is Key program. Additional protections that apply to COVID-19 rental debt: landlords cannot charge late fees or interest on any of the unpaid rent from March 1st, 2020 through September 30th, 2021. And if a tenant is still living in the unit, the landlord cannot apply the tenant's security deposit to the unpaid rent without the tenant's written permission. So this is an important thing to note. This is only true where the tenant is still living in the unit. If you decide or you have moved out of your unit, when you move out, the landlord is allowed to retain your security deposit to cover any unpaid rent that you may owe. So for example, if you move out of a unit and you owed the landlord approximately $3,000 in back rent from the pandemic and your security deposit was $2,500, then the landlord can keep your entire security deposit to cover that unpaid rent, and you'd still be left with a remaining balance of $500 additional that remain unpaid. Some other protections with respect to COVID-19 rental debt. So COVID-19 rental debt can never be sold or assigned if you met the qualifications for the rental assistance program. The qualifications for the rental assistance program were as follows. You needed to be somehow financially impacted by the COVID-19 pandemic, whether that's you lost your work hours were reduced, you lost your job, you couldn't work because you were sick, anything along those lines. And you need to have a household income of less than 80% of a metric called the area median income, also known as AMI. And this box on the slide here details the cutoffs for area median income based on household size. So you can use that to determine if you fall at or below this 80% area median income metric. And so what this means is to say, if you met the qualifications for the rental assistance program, then your COVID-19 rental debt can never be sold or assigned to a third party, such as a debt collector or an account resolution agency. So if you owe unpaid rent for these months and you've been contacted by any type of debt collection agency, that debt may have been illegally assigned to the debt collector, and the debt collector may actually not have authority under state law to be contacting you regarding collection of that debt. Additionally, landlords and housing providers cannot cite COVID-19 rental debt as a basis for denying you from a housing opportunity in the future. If you apply to a new apartment or home and the landlord denies you, stating that they saw on a tenant screening report that you have unpaid rent from that March 2020 to September 2021 period, that under state law is not a permissible reason that the landlord can state as the reason for denying your application for a new housing opportunity. Here's where I'm going to transition to talking some about the local protections. Before I talk about these local protections, it's important to understand that the protections in place around Los Angeles vary depending on where you live, and it breaks down between either the broader county of Los Angeles or if you live in the incorporated city of Los Angeles. So a couple of helpful tools here. If you look at the image on the bottom of the screen, you can see this is a blown up picture of the county of the Los Angeles. All of these areas in white are considered the county of Los Angeles, and all of these areas in this very weird shape in red are considered the city of Los Angeles. Then over here on the right is a blown up version of the red area on this map. So we like to make things a little confusing for ourselves here in LA. So even though we may refer to an area as, one by a specific name, it may actually still be technically part of the city of Los Angeles. So for example, if you look at this map, San Pedro is actually part of the city of LA, despite the fact in normal conversation, we typically refer to it as San Pedro. You'll notice here as well, again, Van Nuys is part of the city of Los Angeles, even though we typically would just refer to it in conversation as Van Nuys. So it's just important to understand this difference and where you fall. At the end of this presentation, I have links to some different mapping tools where you can put in your address to help you determine if you're in the city or the county. So first, I'm going to talk about the protections in the city of Los Angeles. In the city of LA, tenants were allowed to defer rent from October 1st, 2021 through January 31st, 2023. And tenants need to repay this deferred rent on the following schedule. So the first date has already passed, but the first date was that tenants needed to repay any unpaid rent from March 1st, 2020 through September 30th, 2021 by August 1st, 2023 in order to avoid landlords being able to file an eviction for non-payment of rent during that period. The next deadline, which is upcoming at this point in time, is that by February 1st, 2024, tenants need to repay any of the unpaid rent from October 1st, 2021 through January 31st, 2023. And again, this needs to be repaid by February 1st, 2024. Additional protections that apply to tenants in the city of Los Angeles is that landlords cannot charge interest or late fees on any of the rent deferred from this March 2020 through January 31st, 2023 period. So note, this is much longer than the period that's protected under state law. State law says that landlords cannot charge interest or late fees on any tenant in the state of California for March 1st, 2020 through September 30th, 2021. The city of LA protections extended that period so that there can be no interest or late fees on this unpaid rent from March 2020 all the way through January 31st, 2023. The LA tenant protections did expire at the end of January of this year. So they expired on January 31st, 2023. However, tenants in the city of Los Angeles were able to utilize the LA County protections, which I'll talk about on the next slide, to continue to defer payment of rent for February and March of 2023 if they needed it. Effective April 1st, 2023, all tenants in the city of Los Angeles need to be paying rent in full and on time going forward in order to avoid eviction for non-payment of rent. Now I'm going to talk about the LA County protections. The protections in LA County were slightly different. So this again is why it's really important to understand where you fall in those maps I showed a couple of slides ago. Tenants in a county of Los Angeles were able to defer rent from July 1st, 2022 through March 31st, 2023, as long as they submitted a declaration to their landlord each month stating that they were below a certain income qualifications. And these income qualifications were again based on that 80% of area median income metric, and that they were financially impacted by the COVID-19 pandemic. Tenants who submitted this declaration to their landlord each month stating that they plan to defer rent within 7 days of the rent being due were protected from eviction for that month, and going forward have until March 31st, 2024 to repay the rent they deferred under the LA County protections. So notice that there are some key differences here between the LA City and LA County protections. The city protections did not require tenants to provide their landlord with a declaration. The county protections did require tenants to provide their landlords with this written declaration. Notice as well that between the city and county, the dates for what months tenants could defer rent are different, and the dates by which the tenants need to repay any deferred rent are different as well. That's why, again, it's really important to understand which one of these applies to you. At this point in time, effective April 1st, 2023, there are no COVID-19 related eviction protections in place anywhere in the city or county of Los Angeles. All tenants need to resume and continue paying rent on time and in full each month in order to avoid eviction. Now that we've talked a little bit about what is COVID-19 rental debt and some of the protections that apply, we're going to move on to talking about how to know if you've been sued for COVID-19 rental debt and some of the things you need to do in response. So I've already mentioned landlords can sue to recover COVID-19 rental debt in a small claims court or in a civil court action. A general civil court action is broken down to be either a limited or unlimited civil case. If you receive any court documents, the first thing to do is check which type of court case you are being sued in. First and foremost, if you receive any court documents, look to understand and double check that the case is not an eviction. The formal legal name for an eviction case is an unlawful detainer. And I have here on the screen a screenshot of what some of these court documents look like in an eviction case. So you can see that it says all over the document, unlawful detainer, eviction. It's at the bottom of the form as well. A general tip when it comes to looking at court documents is anytime you're not sure what you're looking at, the title of the form is always on the bottom of the page in all caps at the center. So you can see here at the bottom, it says summons, unlawful detainer, eviction, complaint, unlawful detainer. So we know unlawful detainer, that's the formal term for eviction. If you receive any eviction documents, be sure to seek assistance immediately. You have a very short period of time to respond to this lawsuit. So seek assistance at stayhousedla.org. You can also go to your local courthouse self-help center to see if you can get assistance with responding. So be sure to take action as soon as possible if you receive any eviction court documents. If you receive court documents and you've determined that it does not look like it's an unlawful detainer case, then what you may likely be looking at is either a small claims or a civil complaint for recovery of COVID-19 rental debt. On the left-hand side of the screen here, I have a screenshot of what the small claims complaint looks like. And again, a couple of these key ways you can tell it's a small claims case. If you look at the bottom of the page and in the center, the form title is right here. It says plaintiff's claim in order to go to small claims court. So we can pretty quickly tell that this is a small claims case. It also specifically says COVID-19 rental debt in the title. All small claims forms also are labeled with form numbers that start with SC. It stands for small claims. So the small claims cases are pretty easy to figure out what they are. On the right-hand side here is what the complaint form looks like for a civil case to recover COVID-19 rental debt. Again, if you're not sure where to start, you can always look at the bottom of the page for the form title. And you can see here it says complaint, recovery of COVID-19 rental debt. So we quickly know that this is a complaint. It's the document filed to start a legal case, and that is an action for recovery of COVID-19 rental debt. Once you determine that it's a rental debt case and it's a civil case, you'll want to just double check if it's a limited or unlimited civil case. The main difference between a limited or unlimited civil case is just how much money is being asked for in the lawsuit. So if the case is for less than $25,000, the case is considered a limited civil case. If it's for more than $25,000, it's considered an unlimited civil case. And you can tell how much money is at issue in the case because one of these two boxes will be checked under the jurisdiction box. The small claims complaint. The reason I spend so much time talking about this is because depending on which type of court case you have received, whether it's small claims or a limited or unlimited civil case, the next steps you need to take are going to be different. So if you received a small claims complaint, you need to plan to appear in court on your assigned hearing date. So on the first page of the small claims complaint in this box will be your trial date. You need to plan to go to court on that day. That is the day that you will go to court and present any defenses that you want to present to the judge. Some key things to know about small claims court. There are no attorneys allowed in small claims. So you must go to court yourself on that day and you must go and speak on your own behalf in court. If you receive court documents for a limited or unlimited civil case, these documents, again, here on the right-hand side of the screen, then you actually need to file a responsive document with the court called an answer. And you need to file this answer within 30 days of when you were served with the complaint. So, and the other key difference with a limited or unlimited civil court case is that you can have an attorney represent you in the case and appear in court on your behalf. Again, if you've received either of these documents, so the small claims case or the civil court complaint documents, these are on their own not sufficient to evict you. So while the COVID-19 rental debt case is pending, your landlord cannot change the locks, they cannot remove your belongings, and they cannot force you to leave your home, even if you lose the case in court. So meaning you go to the hearing and the judge enters a judgment or makes a decision saying that they agree that you owe the landlord a certain amount of money. The landlord cannot use a small claims case or a civil court judgment to force you to move out or evict you from the property. So that gets us to the end of our presentation for today. A couple of resources that I do want to point out. These are the mapping tools I mentioned that can help you figure out if you're located in LA City or LA County. And on this slide here, I have some information for where you can find up-to-date information on the tenant protections. So, the tenant protections in the city and county of Los Angeles have a tendency to change relatively often. So I would advise checking out these resources and going straight to the source to confirm that the information contained in today's presentation is still up to date. For the County of Los Angeles, the resource for the LA County protections is through the County Department of Consumer and Business Affairs. So that's DCBA. And you can check their website at dcba.lacounty.gov to learn more. For the City of Los Angeles, the main place to check for any updates on tenant protections is the LA Housing Department. So that's LAHD. And their website is housing.lacity.org. And another really helpful resource is Keep LA Housed. They have a really helpful couple page document where they have really nicely summarized the state of the LA City and LA County tenant protections. So that can be another really helpful resource to utilize. So that's everything for today, and thank you for joining us.